Call this meeting to order of the Lincoln County Board of Education, meeting in regular session on Thursday, March 6th. It's 4 p.m. and we're at the central office in Hamlin. The purpose of this work session is to discuss board protocols and how to build a better mousetrap. So that's what we're doing. This time, I'd ask you to join me, if you would, in the Pledge of Allegiance. And Butchie Burns, would you lead us?
I'd be glad to. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you, Ms. Burns. I appreciate that. All right, at this time, I'm going to let Mr. Superintendent Barnett introduce our guests, and we'll begin the work session.
Like all of our meetings, this meeting is being live streamed, and there will be a copy of it available on our website within 5 working days. So without further ado, I want to welcome Mr. Howard Sufer and Jim Brown. Howard has been, I've known Howard inadvertently many years since I've been in education. He's probably the premier attorney for school systems, and knows what he's talking about. So we're very fortunate to have him here to guide us. And Mr. Brown is he is the executive director of the West Virginia School Board Association, and we're going to have a listen today and soak it in and do things the right way. So without further ado, Mr. Brown.
Well, first of all, thank you, and we appreciate the opportunity to be here. You know, we had a chance to talk to President Bell a few minutes before we got started, and this is one of those times when we got to look at this as a way to move forward in a positive way. I'm actually glad to be here because I've spent the last 23 days at the legislature. We're now up to a little over 200 educational bills, and it's been an interesting 23 days. I think you guys have been getting the reports. There's going to be a quiz on that this evening when we finish on all those bills that you've been reading. But we are here for a purpose, and I think we all understand that, with streaming live now, and the State Department and the Office of Accountability, they take a look at how meetings are functioning and things that are going on in our districts. And at times, they have the latitude to ask us to come in and provide some additional training where they think it's needed. Just to put this into a little bit of scope for what we're going to talk about today, there's really 5 major points that they provided to us. I'm here to assist. You guys know Mr. Sufer, and if you've been to our trainings, and his team does a phenomenal job putting a lot of these things that, we think of them as common practices, but then there's always that opposite reaction, or those consequences when we don't. So one of the things that we want to do today is talk about, bring some light to the concerns, add some practicality to it. I hope I can do some of that. This is my 40th year in public education. I've worked as a principal, I've been a director, and worked as a superintendent. So, kind of have a feel of, when the concerns the State Department shared with us, what that might look like for you guys, and how we can weave that in with, the legal side of it, and what are those consequences. Just to add that perspective, some of the 5 areas that we're going to talk about, really comes around discussions and directives made to a superintendent or central office staff that are not a part of the official agenda. What you're going to hear tonight, things that are not on an agenda, the board doesn't have latitude to discuss those things, and should not be voted on during a meeting by the board. So really around developing agendas and then staying true to the process, and then following what the Open Meetings Act says. And you guys, for clarification, you have adopted Robert's Rule of Orders, right?
Yes.
And you're going to be, we have the latitude to use this as a small board, so there's a little latitude because it's a small group, and we'll talk about that. Avoiding ethics violations by maintaining appropriate boundaries with local political dynamics, organizations, and community organizations. I can tell you,
Sean, could you shut that door, please? Thank you.
I can tell you from experience, that's a challenge, because we've got folks in the community that want to volunteer and help us out and do certain things, and there's ways you can do that, but then there's some limitations and there's always some liabilities that come along with that. And really, I guess for you guys as a board, how do we govern that? Third bullet, establishing protocols for relationships, establishing contracts with school support and community organizations that provide monetary support to the schools or use facilities for extracurricular activities. And this is one of those areas where there's tremendous liability when things haven't been codified, whether it's in an MOU or a contract, and then what's expected. It's not always what you have to do as a board or the school system, but there's some obligations by those outside agencies when they use your facilities. And I know firsthand it can be a challenge because I'm sure Mr. Sufer will share some of those limits that they, especially with liability insurance, if they're going to come in and use your facilities. And that can be a challenge for people in the community. So that'll be one of the areas that we cover. Properly representing the board in public situations to avoid the appearance of an individual making a declaration or decision on behalf of the board. When you come together today, each one of you, you get a vote. It's as a collective body. That's where the authority comes, and then it only can happen during a meeting. And if you've heard it, if you've come to our training, and I think everybody's heard it at some point in time. Board members don't have any authority other than what a person on the street have outside of a board meeting. So we'll be touching on that. And understanding the role of the superintendent as the chief executive officer of the school system. A lot of responsibility, having sat in that seat, it really is. But at the end of the day, when we look at that relationship with the board, and it's critical that the superintendent and the board are working in lockstep. But at the same time, Mr. Barnett, knows that that responsibility really falls on you to direct the daily operations of the school system. When those lines start to get blurred, then we find ourselves looking in, maybe having to do some things differently. We want you guys to make sure you feel comfortable asking questions. And again, I just remind you that this meeting is live streamed, so want to be careful with some of the context. We don't want to breach confidentiality in some way that could create another issue that we might have to resolve. So I hope you guys will look at this as, Howard, I don't know about you, but we're both tall, dark, and handsome, so I don't know what else you would want. I think we're actually, no, we don't, we're both about the same height, aren't we, Howard? So, but anyways, we're happy to be here. We want to help you. We want to make sure Lincoln County Schools stays on a good trajectory, and we address some of the concerns the department has shared with us, okay? Mm-hmm. All right, so Mr. Sufer, what's next? I guess what's first?
Yeah. Well, I appreciate the comments that have been made and the nice introduction you gave us, Superintendent. When I come here, and I've been here a lot of times, as I pull in the parking lot, I remember the role that Lincoln County has played in the law of public education in West Virginia. The REC decision that is often referred to, a case that was filed in 1975, I think, and wasn't concluded till 2003, completely upset, in a good way, the establishment law and funding situation for school districts in West Virginia, because it drew attention to the disparities in funding based upon property values and taxes raised in the local county, and as supplemented by the state aid. And we had counties that had far more resources per student, per whatever you looked at, because they were from property wealthy counties, and the whole system was based upon that had advantages over other counties that could, barely keep the lights on and educate students and attract competent people to do that. And Lincoln County's name is on that case because that lawsuit was filed in Lincoln County. It was against the State Board of Education and the state, but Lincoln County was one of the parties to it. The superintendent was sued on behalf of the board and rode that legal ride for decades until it was concluded, and finally the case was shut down. So I always think of this as being a school lawyer, which is all I do. It's all I've done for over 40 years. This is a bright light in the development of school law in West Virginia and the interpretation of our Constitution's requirement that the state provide every student with a thorough and efficient system of education. I took a quick look before I came. I've not been here in a while. I think last time I was here was for a learning session, probably 6 months ago. But over the years, our firm has opened more than 200 files in matters from Lincoln County: grievances, personnel season matters, new policies, requests for assistance and advice. But recently, I've not had that direct contact with you, and I think that makes me feel really good about what we're about to talk about. In this sense, I don't know what's going on here. I don't know if you all people love each other or have problems. I don't know if we've had operational issues. So when I talk about the law tonight, nobody here has a right to think, well, he's really talking about me, or he's talking about this incident that occurred here. I don't know what's happened here in the recent past. And I like having that distance because then I can not have to worry that I might be hurting someone's feelings or insulting somebody when I say this is the best way or the only way to do something under the school laws. So please don't take anything I say as being part of some hidden agenda. I don't know what's been going on. I just know that I was asked to come and address these 5 areas, which I've addressed with other school boards from time to time. And I mean it sincerely, that I'm approaching it as I always do, with what I think are the best interests of the school board in mind. We represent school boards. We represent most of the school boards in the state at one time or another during a school year. We don't represent the superintendent. We don't represent the individual board members. We've had board members that have gotten in trouble. Somebody filed a petition to remove them from the school board for doing something bad, and they'll come and say, can you help us? Say, I'd love to, but I can't because I don't represent individual school board members. Our team of 7 school lawyers represent school boards. And under the ethical rules that we have to follow as lawyers, we have to be loyal to that client. So we work with the superintendents all the time. That's the only way we get things done. They call us and ask us to do things. But occasionally, if there's a falling out between the board and the superintendent, which happens from time to time, we're here for the board. We have to be. And that's the spirit in which I'm offering it. That makes this pairing with Mr. Brown perfect, because that's what the School Board Association's about. They're about school boards and making them function in a way that best makes kids successful and keeps them safe. The emphasis is on the school board, the school district, and not any particular person or any particular interest. So with that as a background, thinking about being here this evening, you mentioned the mousetrap, how to make a better mousetrap. And I'm thinking sometimes if you're setting out to make a better mousetrap, you probably want to go back and review what are mice about, how do we trap them, and how have we been doing it? And every once in a while, it's a good idea to go back to fundamentals. You know, we get so tied up in personnel season and what factors we have to use in determining which candidate for a professional job should get it, and all these intricate things that sometimes we just need to take a deep breath and go back and look at the fundamentals. And so I'd like to take you through a few of those tonight. I know you've been through them before. We've done it at the trainings for the School Board Association, but and I found myself getting away from them. This is personnel season coming up. My mind's all about how do you calculate seniority and does somebody bump somebody else and all. And it's easy to forget what we're really all about. And that is getting the best people in the best places to teach kids, make them successful, and keep them safe. When I started law school, every law school in the country for years, they probably still do it, I don't know, make you take certain courses your first year. You have no choice. And they're teaching you the fundamentals. There's a course in contracts where you learn what a contract is, what it has to have in it to be enforceable, and so forth. Then you got a course in property law and buying and selling property and renting property, and what happens if somebody doesn't carry through on their promise with respect to real estate. And you've got a class in torts, which is personal injuries, automobile accidents, and medical malpractice and all, just the fundamentals. And the year I started, I went into the contracts class, and the professor came in and said, we're going to do something different. We do have to go through explaining to you what a contract is. Does it have to be in writing? Can it be oral? What does it have to have in it to be binding, et cetera, et cetera. But he says, we can get all involved in that, and then at the very end of the course, when the time's running out for the semester, we can talk about what happens if somebody violates a contract. What are your remedies? Can you make them do what they promised to do? Can you get damages or whatever? He says, I'm going to start at that end because I want you to know the consequences of not writing a contract properly, of drafting a contract for somebody that comes in to see you and says, they tell me this isn't enforceable. So I want you to see what can happen if you don't do this right, and then we'll talk about how you do it right. I really like that approach. It's like, you know, it's kind of like seeing the dead mouse on the floor and then saying, okay, or the mouse had escaped. And what are the consequences of that? So I put a little slide together here. Yeah, I think you know everything I've got on this slide. But we're talking about 5 issues this evening that are really important in terms of how school boards get their work done and how they perform their duties. But so from time to time we have a slip up. We don't follow the open meetings law properly. We forget that there's a law in the law books that says we have to do something a certain way. Whatever it is, we get a grievance, we get a court case, we have other consequences. I thought I'd list these consequences here and remind you. The very first one is legal proceedings. You know, if there's an error from a legal standpoint in what the board does, and somebody believes that they were harmed by that or disfavored by that, we have processes where they can go to court and sue you, or they can go to the grievance board and file a grievance. They might file a proceeding in the Human Rights Commission. There's all kind of forums like that. But legal proceedings are one of the most common results of not complying completely with the laws that govern how a board operates. And as you know, they're sensational. You're covered in the news media. People are watching to see, did you really screw up? Will the court say that, or will you be vindicated? It's expensive. You usually have to have lawyers. You got employees that have to leave their jobs to testify. They go on and on and on. So legal proceedings are a really important consequence of a breach of the school laws. Nullification of board action. We've had boards in this state that have gone through the lengthy process, months long, to properly close a school and consolidate it with another school, and have finally voted to do that, and with all the public pressures and everything, and they had a court turn around and say, sorry, we're reopening the school, you did it wrong. Like, why did we go through all this? Under the open meetings law especially, if you take a decision at a board meeting that isn't on the agenda, which Mr. Brown was referring to, and that should have been on the agenda in order to even discuss it, much less make a decision. And if somebody goes to court and convinces the judge that the open meetings law was violated, one of the things the legislature has told the court it can do is to wipe out any decision the Board of Education made when it violated the open meetings law. A delegation came to see you this evening and brought something up that wasn't on the agenda, and you all discussed it. You didn't even vote, but you discussed it, and then at a later meeting you voted on it. Someone could arguably go to court and say they violated the open meetings law by discussing it. They couldn't forget that discussion when they voted on it next week. It infected their decision. Judge, nullify that decision. So nullification can be a result of the breaches of the school laws. And it's like, why do we invest all the time and effort to decide something if now it's thrown back at us, and now it's really difficult to go back and do it right? Of course, monetary liability for damages. Sometimes people can show that they were harmed financially, and it might not be an employee, it might be a contractor in the community who claims that competitive bidding wasn't done properly and they should have gotten the contract to do the new school, and they're entitled to their lost profits. There's also monetary liability under some of the laws where you can be fined, for example, for violating the Ethics Act. The Ethics Commission can fine you up to $5,000 personally if it finds that something you did as a board member violated the Ethics Act. And then just the cost of fighting these things and defending yourself is also an enormous monetary expense. The loss of public trust is another result. if the public believes that the board is not following the laws, and if the board in fact is not following the laws, or it appears that they're not, even though they are, then you can have members of the community that begin to, their trust in the board begins to erode. They begin to question the board's decisions. Like if it looks like they skipped a step here, what other steps are they skipping? And that's not a healthy thing for a board that really relies upon the support of its community, even when you make hard decisions. If people believe you did them the right way, they may disagree with you, but you probably have fewer people that will resort to other means to challenge it if they trust that, yeah, you did it the right way, we just disagree with what you did. Your damaged reputation's kind of tied into that, but you can individually as a board member see your reputation damaged. If you, as a board member, stepped across the legal line someplace, and that's noticed and publicized either in an election or just in the media, it can damage your reputation for all time. Some people will never forget if they are convinced that you violated a law that you should have followed as a school board member. Then there's state board intervention under the West Virginia Code. And as you know, the State Department has an Office of Accountability, with which we're all familiar, whose job is to be sure that school boards are meeting at a minimum level their legal responsibilities. And there are other responsibilities under state board policies and contracts and other things that require boards to do things that some boards don't do. And if the State Board of Education feels that that's a big enough problem in your county, and typically after giving you some time to correct your ways, they can actually intervene in the operation of the school system, which sounds more technical than take over, but that's what that means. It means that they can come in and actually take over completely the function of the Board of Education. You still have board meetings, you still come to them, but you're just coming to say the pledge to the flag and hear a report from the superintendent about what decisions your appointed superintendent has made with the state superintendent of schools when it comes to filling positions, passing budgets, paying, all of that can be taken over. And you still come to your board meetings, but you're just there to hear a report. You're not asked to weigh in on these issues. Or they can intervene in just part of your system. They can take over the finance function or another function. It's sort of a drastic thing, but right now we have a couple of counties in West Virginia that are under state board intervention. They've replaced the superintendent who was there when the intervention occurs, and then have a superintendent that works with the state board and the state superintendent and the State Department to run the school district, while the board members look on and say the Pledge of Allegiance at the beginning of every meeting, maybe approve the minutes, and adjourn. Personal financial liability. It doesn't happen often, but if you as a board member participate in an unauthorized expenditure of board money, there's a law that says it can be recovered from you. And not just the amount that was unlawfully expended. Even though you didn't get the money, it went to somebody else. It shouldn't have gone there, and you should have known better than to let it go there. You can be made to pay it back, and then they can multiply that and make you pay more back to teach you a lesson and to make you an example for other people. Criminal convictions should have been a little higher on the list, I think. We're all worried about that. But people don't realize that some of these laws we have to follow have criminal consequences if we don't. You know the open meetings law. If you know better and violate the open meetings law anyway, maybe you say, oh, no, it's not on the agenda, but we're going to talk about it anyway. That's a crime. It's a misdemeanor crime in West Virginia. And if somebody wants to press the point, in the back of the open meetings law, it says that you can be fined and be convicted of a misdemeanor. The finance laws, the Ethics Act, the pecuniary interest statute, those things can carry some pretty heavy and unauthorized expenditures, some pretty heavy criminal penalties. You got something on your record for a long time, and you may have to spend a little time in confinement and pay a fine. If you have any professional certifications, and those of you who have been educators before probably do, they can be taken away from you for violating some of these laws. And finally, you can be removed from office. If the breach was intentional, it can be viewed as one of the grounds that citizens can get a petition up and have you removed from office by a 3-judge court that considers the charges and determines whether they were severe enough to require your removal from office. Those proceedings can also be brought by the prosecutor without a petition of the people in the community. And there's some other procedures that attend it. But those are I think you're aware of all that, but I just wanted to remind you before we went into it that that's the background we have here. That's why these things ultimately, we should be doing this because we're sworn to follow the law, right? You all took an oath when you got on the board. That should be enough. And it is, I'm sure, for you. But just as a background, we need to know that there are these other incentives for staying on the right side of the law and not straying into territory. And they often say appearances are sometimes the same as reality. And I encourage you to think about that as we go through these next 5 sections here. Sometimes you're not violating the law, but people can't tell by looking at you. You're doing something that seems suspicious. And I think about the rule that says that 3 board members outside of a board meeting can't get together and discuss business that's going to come before the board, right? That's like having a meeting in the parking lot. You can't do that. 2 of you can, but 3 of you can't because that's a quorum of the board. And I know board members that be in the heat of argument, something where the community's really divided, and think that these board members aren't, coming over to our point of view. They may not be doing things right, and then they see 3 of you sitting at McDonald's on Saturday morning having coffee and kind of whispering to each other. And you may be talking about the ball game the night before, but they'll never believe that. They'll see you over there, and they see you're 3 people that are causing the problems here. And that doesn't mean you can't go to McDonald's and sit with all 5 board members. And all 5 of you can get in a car and drive someplace to an event. But you have detractors sometimes that see things, and that's just an example. I use the open meetings law as an example, where you might think, are we in a situation right now where people might think we're violating the law even though we're not? And if so, is there something we can do to not change our lives and have to live in, as hermits, but at the same time can not give rise to any of these suspicions. So think about that as we go through that this evening. So with that, I thought it was a good idea to go back to some fundamental rules. And they apply to all 5 of these areas we're talking about. But they also apply to everything else that you do. And you've heard these before. But again, sometimes we get so far down the road worrying about details and other things, we don't go back to fundamentals and think about it. So the first of these is the school districts only have certain powers. There's some things you would love to do and I'd love you to do that you think would be of the interest to kids that you can't do because you have to find a law passed by the legislature or a policy enacted by the State Board of Education that says you can do something before you can do it. In our personal lives, go do something, you go to do something, somebody says, you can't do that. You say, show me a law that says I can't do that. It's just the opposite for school boards. Our courts have told us the question should be, show me a law that says you can do it. And the laws in West Virginia are the laws passed by the legislature, the policies of the State Board, which have the force of law, some court decisions where the Supreme Court of West Virginia says, here's an uncertain area of the law, we're going to rule that this is the law, that becomes the law. So we have to look at those and be able to justify everything we do if it's challenged. The Board of Education has only those functions given to it by law or that rise by necessary implication from the powers that you've been given. It's been said that school districts are corporations of the most limited power known to the law, and that's so. And I cite you here in the handout. There's 2 handouts. The main handout I'm just going to call the handout. The other one looks like a board policy we're going to talk about at the end. But I've given you a handout that we had at the orientation session for new school board members, probably when you took your first time you took a seat on the board. And the very first principle we have on there is that a board can exercise only powers as expressly conferred or fairly arising by necessary implication. And then, if the law tells you how to exercise them, you got to do it the way they said. If you do it any other way, you've crossed the line. A second fundamental is, and this is what Mr. Brown was referring to, is that you as an individual board member have no authority of any kind in connection with the schools of your county. Outside of a board meeting, acting as an individual. The only person on this board who can do some things outside of the board meeting as an individual It's because they're the president of the Board of Education. And that's limited. Very few things. And Mr. Bell will tell you, they're not things that anybody would want to do. Having your name on all the checks, having your name on all the requisitions to purchase money, appointing a representative of the board to sit with the 4-H, some things like that. But even the board president doesn't have the authority to make decisions on behalf of the board, to bind the board, to enter into agreements or negotiate agreements for the board. And at orientation, we often, of course you'd be wise to it because you've seen it, but we often say, let's all go over, when it was in Morgantown, we'd all go outside on that porch behind the conference room after the break, and I'd say, now there's going to be somebody that comes walking up here. If you know who that is, don't tell anybody. And then we're going to get back together and see who recognized them. And we all would stand out along that big porch, and everybody be training their eyes. They have that rails to trails paths there. And then the person would come walking up, come by slowly, and everybody would watch them and all. And I'd say, don't tell anybody who it is. And we get inside and we say, who is it? Does anybody know? Oh, that's, Governor Justice's wife. It's the Attorney General of the United States. It's Jennifer Garner. It's whatever. And those were all wrong answers. The answer was, it's a person off the street who has the same right as you do to tell people what to do at the school board, or to walk into schools and direct people to do things a certain way, or to order the superintendent to do something. You have no more authority as an individual board member to do that than this person on the street. And the person that walked by was just the first person I saw that came walking down that path. I didn't even know who it was. But the point was that in the courts of West Virginia have said that as individual board members, you have no more authority than that person on the street in any aspect of the school district, unless at a board meeting, the board decides that that's what we're going to do. The board decides that's what we're going to instruct our employees to do. The board adopts this policy. So that's an important fundamental. This is a quote from our Supreme Court. The law doesn't contemplate that the members of a Board of Education shall supervise the professional work of teachers or principals and superintendents. Board members are not teachers and ordinarily aren't qualified to be such, and that's another item on our handout from orientation. The law clearly contemplates that professionally trained teachers, principals, and superintendents shall have exclusive control of these matters. So you got to be careful wading into that territory, even as a school board. A fundamental is that when it comes to matters of discipline, methods of instruction, other things that are the professional work of your teachers and the other people that work with you, they're the ones who make the decisions. And we had a case here where board members wanted to fire someone at a school district that the superintendent hadn't recommended you take any action about. And they went ahead and did it anyway. And they said, this person's not a good teacher. And the Supreme Court said, that's not the school board's business. The superintendent will make that judgment and then bring it to you if in the superintendent's judgment, professional standards have been violated.
Howard, if I might, I got a question, because I don't know if this perspective will help me, maybe Howard. Can you tell me how many years you've been on the board?
Since last year,
What's that?
2022.
So this is your.
No, I'm sorry, 2024.
So this is your second year?
Yeah.
Okay. Jeremy,
Since 2022.
second year? David,
2.5 years.
2.5 years? 2.5.
2024.
Wow. So you guys are actually you're all pretty new to this. David, were you a board member previously?
No,
No. So this is.
just
so-
a school person.
So really, 2.5 years, and Mr. Barnett, you've been superintendent for
A year and a half.
a year and a half.
So you all have been through the orientation and heard this once, but you haven't had this drilled into you over and over again like will happen if you're on the board for a long period of time. I don't mean to discourage you from staying on the board.
So when you hear that, and I know you went through the orientation, but when you ran for election on the board, that didn't seem right, does it? When you really think, let's put it this way, folks in the community, if you were at Walmart and somebody come up and said to you, hey, you know what, that's been a real problem down at that school, we'll just leave it generic like that. And if you pulled this PowerPoint out and said, well, I just went to a training and this is what it says, how many people do you think you could convince in that day at Walmart that's actually your latitude as a board member?
Not many.
Not many. Hard to find any, when you think, because they always come to you with the problems. And they expect you to fix them, because if they tell Daniel and he doesn't answer it, where are they going next? They're going to Jeremy, and if they don't go to, they get to Jeremy, they're going to Robert, and then Sheila, you're gonna probably get the last. And David, you're the president, you gotta be able to fix this, right?
David and I got a lot of that, 'cause we were both high school principals. So we had a lot of community people coming and talking about things.
So when you think of this, then what actually is the response when you get these? Because according to what Mr. Super has read to you, doesn't give you, I mean, that law book is about 600 pages now. It's probably about an 8 font. So that's a lot of laws that you gotta follow. And there, really, if we went through the statute and pulled it all out, it says this is what you have the authority over, you'd probably be pretty disappointed. It's probably maybe 3 pages, Howard, 4 maybe. But what's the one commonality? It's gonna be intertwined to all of those pieces of statute. One person. Who do you think that is? So if you can't do all these things, who's the one person in the system that really has that direct authority?
Superintendent.
Superintendent. I'll be honest with you, when I read the law on that the first time, if it doesn't shake you in your boots a little bit, it ought to, because at the end of the day, that is where that responsibility lies. So when it comes to all this, in your mind, the first words that should come back is, I'm gonna have to speak to the superintendent. We'll have to look into this. I'll talk to the superintendent. And then at the end of the day, one of the responsibilities you as a board in this regard is holding the superintendent accountable for the work that has to be done in the system. But that's tough. I think if I was one of you, and I didn't know that, and I ran, and I walked in for the first time, I'd be like, I actually had a board member told me one day after she went through the orientation, Howard, this is a true story, she was ready to resign. Because she was just so discouraged, because she wanted to get in there and, fix A, B, C, and D, but that's not the role. Is any of the, I know you heard it once, but it always helps to hear it a second time. Anybody thoughts on this, or, yeah, it's tough in the community,
Yeah, it is.
because they're mad. I mean, Daniel, they're mad.
They think everything is a board problem.
Yeah.
And that we have to fix it right then, the way they want it.
And I knew that going, and I love telling people to call Frank.
But I usually call him before I tell him to call, or immediately after, and say, look here, so-and-so's gonna call you about this.
If I already know the answer for Sheila and David. Any one of you 3 type A personalities? You are, I can tell that already. They're sandbagging me a little bit. He's a good poker player, but you're type A, right? Fix it kind of guy? Robert?
Yeah, that's
Yes.
just,
Jeremy?
I've been told all my life type B personality.
So there's your thermometer in the group, guys. He's going to keep you grounded. But type A folks, it's really, you feel like you're not doing your job. But embracing what that job really is, and it is really to help your superintendent and execute his duties and being that conduit sometimes.
Yeah, I think
That makes
that's the
sense.
important part. If we know something's wrong out there and that the parents and the community is upset, it's Frank's right to know that. He needs to know that.
More so than anything, it's
That's
definitely his
exactly right.
responsibility, just as you two when you were principal.
Yes.
I'm sorry, Howard, I mean.
No, that's very important, and it's also helpful, because I don't want to repeat things you've heard over and over and over again. I'll just tell you things you've heard once or a second time. One more piece of these fundamentals. The law is very clear. If your Board of Education adopts a policy, and it's in effect today, you must follow it, unless it violates state law or federal law. So you couldn't have a policy that is illegal and then say, well, we had to follow it. Hopefully all your policies are lawful. You use the Neola Policy Service, And I know that they have people review those policies. We used to do it in our law firm years ago. There's another firm that does it now. So you're pretty much protected against there being something in a policy that leads you to believe you can do something that's illegal. And a lot of boards don't have the Neola policies. And that's fine. They don't have to have them. But you have them, and Jim gave me the 5 points we're to talk about today. I said I can pull some laws from the legislature and so forth to give the board members. But let me look at the policy manual first. And your policy manual is comprehensive. It addresses every topic we're talking about here tonight. And so you need to know that the courts say that you have to follow your own policies. It's not like a suggestion. A policy isn't something you just pull out of the glove compartment when the engine warning comes on your dashboard to see what in the world is this about. It's a recipe book of what you can and can't do and how you do things. And for the most part, it's very well done. And I was really surprised when I went through on these topics how many of your policies popped out at me. So that's why on pages 5 through 30 of the handout, just a few of your policies are there that touch on the topics we're talking about. You have no choice but to do what those policies say, even if you disagree with that, until such time as you would follow the proper process to modify them, which usually involves making a motion to put it out for public comment and getting comments and then bringing it back to the board. You can't at a board meeting say, well, I know our policy says this, but I move we waive the policy and do something else tonight. You can't do that. So it's really important, and it's hard. You can't read that. That policy manual is as thick as the law book he was talking about. But if you know something's coming up, or there is an issue, it's easy to find in there if there is something that your policies already require you to do in this situation. You got to also follow, of course, the policies of the State Board of Education. The legislature has said so.
Howard, if I could ask a question of the group. And I've been criticized for this, but, you know, when you do something for so long, you just can't can't forget it. You know what I'm saying? There's certain things that jump out. So first thing, you guys pull this, you guys on the handout, the big thick one. Into those pages Howard was just talking about. And there's one thing outside, I love your logo, one thing that jumps out on all those policies except for one. Anybody have an idea what jumps out when you just look at this? Just leaf through it. Don't read anything, just look at it. See if there's anything that jumps out at you. I know, Frank, come on, you got, David, you got to smile a little bit.
I'm just trying to figure out what you're saying here.
I know. I'm just saying, there's got to be interaction at some point.
An individual board member, whether at or outside of a meeting, has no authority.
Yeah, that's good. So I'll make it easy, I'll make it quick for you. I looked at each one of these policies, outside of one, there's only one that's been it's adopted. I don't see where it's been revised, where it's been refreshed, or anything. Every one of these policies are all dated 2011. And as a superintendent, I will tell you, Frankie, I don't know, when you inherit a system, I did as a superintendent as well. One of the things that I think that helps county boards, if you put your board policies on a rotation, and every 4 years, you're revisiting those policies. And they may not need a revision. They may still be right in line with state statute, federal code, whatever it might be. But the other part of it, it requires us to take a look at our policies. And you guys came in all 2 years ago. And that's one of the things, oh, I'm sorry. One of the things that I think where we see a lot of success, you have a superintendent in place for a good while, and you have consistency in the board. And when I say consistency, 3 in, 2 out. You know, folks do 2 terms, 3 terms, and the change on the board isn't dramatic. For you guys, it is dramatic. I mean, all of you guys are new within a couple of years, and all of these policies that really speak to how you all function, the date says 2011. Now, I could be wrong, David.
I'm sorry, Jim, I don't hear well.
Okay.
Are you saying those are Lincoln County policies?
Yes, they're yours. Right out of your
We
meeting.
have, as a board, we have undertaken policy revisions. We've had several special call meetings to do that. And we've revised a whole number of them.
People just sent in, these are the ones that were on last night, on Tuesday night.
Yeah, you have,
No,
you
we
have some,
haven't
they
done
have some
that.
newer policies that are within the last couple of years.
Yeah,
And some that have been revised. I looked at some of your personnel policies just to get a sense. I suspect that these policies don't get revised as often because these are things that change
Well, we've
with
still got
every
a long way to
legislative
go.
session.
We've got a lot that
Yeah.
still needs to be looked
Yeah.
at, but quite frankly, the number of board meetings being cut back kind of hampered that a little bit.
Right. It will help all of you to learn what's in these by going through a process. And these are, and I think Howard's alluded to, these are somewhat benign, but, so maybe these are policies that you look at in the summertime. And, you know, well, how many of them are there, Howard, you know? You recall quite a few. And then again, somewhere in this, you may want to decide, you know, are all of these policies actually necessary? And that's a story for another day. But when you see something that has a 2011 date on it, and if you end up back in one of Howard's slides in one of those binds and you violated one of these, somebody might say, when was the last time as a board you revisited these policies? And it would help in the learning process. I don't want to belabor this, but you should not have a policy that's not as outdated as this is. Language might be fine, but it needs to be something that you look at on a continual basis. That also helps when you bring in new board members.
And apparently you've done that a little bit. One of the policies there on page 11 is the public participation at board meetings. And it was adopted June 21st of 2011, but then it says last revised November 28, 2023. So it looks like you've done some of this. It may be, as Jim says, the policies that haven't been changed are benign in the sense that they're about age-old wisdom that wouldn't change a lot.
anyway.
Yeah, about board members not being able to bind the board and so forth. But it doesn't mean they should be ignored. It's really important to take a look at them. So with that, Jim, you want to kind of tee up the next section of this? And then we'll briefly go into each of these areas. Jim's going to tee them up. I'll give you a little legal advice. We'll sum it up and then move on.
Individual board member, whether at or outside of a meeting, has no authority to supervise or give directives to any of the board's employees. Enter into agreements that bind the board of any of its employees. Give assurances to anyone about what the board might or might not do. So this goes right back to the previous slides. And on a practical side of this, what would that look like? So supervise or give directives to any of the board's employees. So you get a phone call. For example, there's a problem with the concession stand over at the high school. And, you know, somebody, maybe it's, I don't know, it's one of the volunteers that kind of work on the football field or something. And they say, you know, Daniel, we need to go run out there and take a look at this concession stand. This really needs to get done. And then Daniel calls the facilities director, maintenance director, and says, you know, I was just out there and this needs to be replaced. Now, when a board member asks you, it might as well tell you to do something. There's an assumption, right, that I got to do that. I'm the facilities director, he's a board member, I've got to go do that. Based on what the statute says, you don't have any direct authority to tell to direct anything, because at the same time, you're also spending what?
Money.
Funds. And that may or not be included in the budget. And now, we've got an unauthorized expenditure on top of that. Or maybe it's, you know, it's a volunteer group that's gonna come in and you say, and you know, Jeremy says, yeah, we've been needing to get that done for a while. Go ahead, you got a couple guys who come in and do that this weekend. Yeah, we'll do that. Now I'm gonna tell you a story, and my friends in a previous county will allude to this. They had a football field, volunteers built it, and that was amazing. They had put in a brand new press box, and it was high. It was really high. Brim came in and said it was too high and it needed to be brought down. So as volunteers came in, nobody really remembers who directed them to do that, and they dropped that down to the acceptable height. Problem solved. Fast forward 20 years, and I'm superintendent, and we're doing a big project. And one of them is to do some remodeling work and shore up some things on the press box. I'm on vacation, my phone rings, and the gentleman's doing the work. We bid it out, contractor, whole 9 yards. He said to me, he said, Mr. Brown, he said, you know, one of the things you didn't tell me about is your press box is not mounted to the standards. Excuse me? The press box is not mounted? What do you mean by that? He said, sir, he said, it is just sitting up there. It's like 20 years. And I'm telling you, there's a hollow that comes right down through that, and you know what that means on a bad stormy day. And I can only visualize that press box sitting in the middle of the football field and me having to answer to the press. How did that happen? Can you imagine the liability on somebody? And there's been a couple things in the paper a few years over last year where there's been some volunteer work and not the code. But here I am, as a board member, I kind of gave a directive to somebody that didn't have authority to do that.
But did you know that you didn't have the authority?
As a board member?
Yes.
You never have the authority.
No, but did he know he
Oh.
didn't have it?
And I'm probably going to use ignorance of the law is no excuse.
That's
It's
true.
liability still on the district, and.
Well,
and-
everybody, you know, in the country anymore, you know, in little communities and counties, they just assume that we have, you know, so they call us and they say, you know what? This principal over at West Hamlin, you know, is blah, 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 and we want you to take care of it. And I always say, I'll talk to the superintendent about that.
Sheila, you're exactly right.
Yeah.
People, you can tell them about this till you're blue in the face.
and they
still-
just don't
It's
get it.
natural.
Yeah.
They elected you, and they expect you to do something.
And I expect to do something, but I expect to do the right thing.
So the one thing we gotta go back to is, we actually have no authority outside of the board
Mm-hmm.
as a collective body and during a meeting. So any of those three things on that bullet you might do independently, that's stepping outside your scope. And that's the kind of things that one of the reasons why we're here, guys. Somewhere in all this, maybe unbeknownst to you, or maybe it is, you guys have to function in lockstep, and you have to avoid any of those scenarios, because those are the things that are actually why, one of those things is why we're here. And you know what? Daniel and Jeremy might get walking out in the parking lot, see Robert going over there and going, I didn't know. And that's okay. But after today, those things, that bell needs to ring, and you have to say to yourself, I can't do that. Even though that's the way we have
Done it.
always done it. And that's critical to put that in context.
You know, 2 points about that, and Jim made one of them. You always got to think of the recipient of the message you're giving. You talk to an employee, and as Jim said, suggest, you know, I think you should do this. Or you do say, you stop doing that, do this. They're hearing from their boss when you do that. And you might think you made a request. The human thing is, I'm concerned about my job. I want to be sure I do well. Board member so-and-so told me to do X, Y, Z. I better do it. And it puts employees in a terrible position because they're not supposed to take orders from individual board members. No employee is insubordinate or can be found guilty of insubordination for refusing to do what an individual board member told them to do that wasn't something decided by the Board of Education itself. But they don't want to look insubordinate. You know, they may say, well, I'm not going to do it. I don't have to do it. And then they're thinking, okay, is that going to come back on me sometime because I've defied the board member? The other point is on this slide. Just because you're in a board meeting right now, you still can't, as individuals, tell people to do anything and legally expect them to do it. It's got to be the board that makes that decision. You're a corporate board. So yeah, it isn't a thing like, well, I'll wait till I'm at the board meeting, and then you come to the meeting, and I'll tell you what to do, and you better do it. You can't tell the superintendent as an individual board member, hey, go get that file. I heard there's something going on with such and such an employee. I'd like to see their evaluations. It doesn't matter whether you're at a board meeting or outside of a board meeting. You can't do that unless the board itself has decided to do that, and then they can only do it in areas where they lawfully can, like there's you're filling a vacancy and you want to see the evaluations of one of the candidates because you've been told that they had bad evaluations, then you can see it. But you can't go on fishing expeditions as a board, much less as an individual board member. So always remember, whether your view prevails or not, you're a corporate board. The board has to decide to do something before it becomes an obligation of the superintendent or an obligation of any of your employees. But employees may hear you ordering them to do something even though you were carefully chose your words and you tried to make it into a suggestion. You can read on your own, pages 43 through 46 of the handout. I've given you excerpts from opinions of the state superintendent of schools on this point, and they all reflect what the courts say. I thought it was a nice way to condense it down to just a couple paragraphs. They all say the same thing. Now, you have a board policy, and I think you started to get into it here a moment ago. Policy 9130, it's on page 22 of your handout. It says the same thing. And remember, you have to follow your board policies. You go to page 22, and you'll see right in the middle of it, matters, well, this is your complaint process, public complaints about the school board. And if you go to page 21, the third paragraph, any requests, suggestions, or complaints reaching the board, board members, and administration shall be referred to the superintendent for consideration under these procedures. So you've already decided as a board, because you adopted this policy, that whenever the public comes to any of you with a complaint or a concern, you will forward it to the superintendent, and that's your action. You're bound by your policies. And if you don't follow your policies and some misfortune occurs, then we've really got a problem because we've breached the law. This is the point, that if you give it as an individual, not as a board, give a directive to an employee and they don't follow it, it's not insubordination in the eyes of the law. They can say, no, I'm not going to do it. Now, a lot of employees won't do that because of the dynamics, but they don't have to do it. And an employee cannot be punished for that. It can't be taken out on them in some other way, get the reduction in force time. Well, we're just going to eliminate that position. We don't need it any longer. Not that you would do that. But you want to be careful about even indirect sanctions against somebody who has legally refused to do something. Now, you can issue as a board orders and directives and expect people to comply. If you're authorized by law to do it, remember, we don't say, where's the law say we can't do it? You got to find a law that says you can do it. You complied with any conditions or procedures that the law has in it. It might say, yeah, you can award bids for buildings, or you can build buildings, but you got to have a competitive bidding process. So you have to follow the procedures. It has to also comply with your own policies. Sometimes your own policies are less generous than what the law would require. You've chosen as a board, or your predecessors have, and the board's the board, regardless of who's sitting around here, to pass some policies that even restricted your authority more than they had to. But we've got to follow those policies because your county policies have the force of law. And you can take action at a duly called board meeting to direct somebody to do something. It has to be by the board itself, by vote of the board at a duly called board meeting where the agenda reflected that this item was going to be considered. You can't have something that just comes to your mind at a board meeting. Delegations are speaking, for example, and somebody brings something up about a leaking roof at a school. You can't just start talking about that, or whether you decide to do anything or not. You can't talk about it. You can't decide unless it's already on the agenda. If you do, then you're operating outside the boundaries again, and you're giving directives to people that you can't give them because the matter was not on the agenda. And again, that's a fundamental point that was on the handout there at the beginning of your materials that we gave out at the board member orientation. Now, another thing you need to think about as a board, now we're talking about the board taking action, telling people to do things or how to do them. There are some areas that are off limits. We've already talked about the area that our Supreme Court has said that A board does not judge professional competency, curricular matters, things that are within the expertise of teachers and professional educators. So we already know we got to keep our hands off of the specifics there. There are laws that tell us what the superintendent is to do, and I've given you a reference to them here. In the interest of time, you can read those yourself if you want to. They're in your handout. They've told us what directors and assistants and supervisors do. They've told us what principals do. We can't veto what the legislature's told our people to do, and they've been told to do it without having to come to the board to do it. Your superintendent is required to follow the policies of the State Board of Education. It's in one of those laws. You can't, by a vote of the board, make the superintendent not follow a policy of the State Board of Education, because there's a law that independently gives the superintendent that responsibility. Same thing with some things that the law says about principals and what their prerogatives are and their responsibilities are, and other administrators. And there is the state superintendent of schools, by law, has to answer legal questions about school law that people ask, and has to do so in writing. And there are hundreds of those that have been issued over the years. Usually they're in areas of the law where there is no real clear law to go by. Somebody will say, does the law allow us to do this or allow us to do that? And we've got a database of all those at the office. I think we've got the only full database of those outside of the State Board of Education. I went searching in it, looking for a state superintendent's interpretation, which we follow. It's he's the chief legal officer or school officer in the state, looking for one that illustrated this point, that there are things the law give the superintendent to do, or the directors or the principals, that even if you want to, and even by unanimous vote, the board has to leave their hands off of it. And by golly, it turned up this 1994 interpretation written to the Lincoln County Schools. The Lincoln County superintendent, and you'll see it in the materials at page 40, had written to the state superintendent and says, can the board second-guess principals when it comes to the way they discipline students? Can the board, there you go. And there are other questions about the board, and they went to these points of law, and the state superintendent pointed out that the courts have said, and he believes, it was a man at the time, believed that no, there were areas where you can't second-guess a principal. Even though you're in charge of the school system, if the principal decides a student should be suspended, you cannot have a motion here and unanimously decide the student should not have been suspended. Now, if it comes to you as an expulsion, where the law says there can be a hearing in front of the board and says the board members make that decision, that's different. But you can't reach down and somebody's complained to you about somebody's not able to play football on Friday because they were suspended by the principal, and the board wants to see that they play football. Even by unanimous vote, this interpretation tells you that it's not the board's business. Jim?
There's two things that I want to look at the list that the State Department provided to us. Better agendas in following Robert's Rules of Order. If you think about those two aspects of it, that's going to help you clean up a lot of this stuff. Because there are things that are going to come up. What do you do with that? Well, at some point in time, you need to be able to have a discussion about it as a board. So how do we get something on a board agenda? And then once we do have, we've got a clean agenda, things are functioning well, you have a mechanism to get something on the agenda, and then following Robert's Rules of Order. If we want to do something, or I want to do something as a board member, well, I've got to make a motion, and then somebody's got to second it, and then it's a prerogative of 3 board members. Hopefully we get a 5-0 vote, but we've at least got to get 3, and that helps you stay out of, it's my decision, I made this, and we bring it to the board, we put it on the agenda, and there's a mechanism to do that. Your county policy, I'm guessing if you have Neola policy, it's going to tell you, if 3 board members request something to be put on an agenda, and it's usually the board president or superintendent collaborate creating that agenda, and during a meeting, at some point, you have an item on the agenda, board member concerns, or agenda items for future meetings. Make a motion, get a second, take it to a vote. You use those 2 aspects, good agendas, a thorough way to get something appropriately placed on the agenda, and then use the process of the Meetings Act, Robert's Rules of Order, to follow legally how we approve something as a collective body. I mean, I think if we don't throw that in there, because you're going to be sitting there going, okay, they said all this, but, well, how do we function? Well, it's because you got really good agendas. And your conduit, again, is your board president and your superintendent.
One of the points that was made at the meeting was that wanting us to utilize board docs to put our agendas on. Well, in the platform we have with Neola, it only provides for a space for us to put policies, not agendas. So I reached out to Board Docs, the company, and was just going to have that component added, at our cost. And they finally, after 3 or 4 days, called me back when I was online with this associate from Board Docs Forever, and he said that they're doing away with Board Docs as you know it, and to get this product.
Yes.
Yeah. So Diligent Community, correct. So when I contacted, what's his name from Neola that was down here?
Sam Calbar
No, it
or
wasn't
Blaine
Sam.
Hess.
But I contacted Neola, their representative come down and talk, I'll think of it after we leave. Came down and talked to me, and he said, well, then I got a correspondence from him a little while later, says, cool your jets on that, don't do that yet, because Board Docs has not communicated with Neola that they're changing anything. So we're still kind of in limbo on that.
So Diligent, we just actually, ironically, you brought that up, we heard from another county that's been using Board Docs, and they just got word it's a 90-day process to convert over to Diligent Community. The problem with that is the expense there's an upcharge. Eventually, folks are not going to have the option to stay with the old Board Docs version. It's all going to start merging over to Diligent Community. I'm not really familiar with why you wouldn't have had that as a component all along. But that format for agendas is very, very, very impressive, actually.
Well, the mechanics of that, the State Department may prefer that you use a certain product to do that. The law says that you have to have an agenda for every regular meeting and a statement of the purpose of every special meeting made available to the public and the news media at least 3 days in the case of regular meetings before a meeting, or 2 days. And that you have to have a policy specifying how that's going to be made available to the media. So in some counties it says we'll post it on the front door of the board, we'll put it on our website, and we will email it to all the TV and radio stations in the county, something like that. And the important thing here for our purposes today is to be sure that when you do give a directive or you do make a decision that it's legitimate, it has to appear on the copy of the agenda that was made available to the public and the news media. And if it isn't on that, then you cannot consider it, even though it might have been on an agenda that you all got in a packet before the board meeting. It's got to be on that agenda or the call of a special meeting that the public and the news media could see in accordance with your policy saying where those things are published. And if there's, Board Docs is hard for a lot of members of the public to get into and read and understand the agenda, but it's there. But it's not the only way. And the law, if somebody challenges what you did as being in violation of the open meetings law because it wasn't on the posted agenda, 2 questions will be asked legally. 1, did you post your agenda in accordance with your policies? Make it available to the public. And then 2, was this matter reasonably reflected on that agenda? And it's not enough to say new business or items that are brought to our attention during delegations. It's got to be more specific than that. So yeah, the business of Board Docs and the transition and all, it can be confusing and expensive. In the eyes of the law, the state statutes, the open meetings law, the question's going to be, we really don't care whether you're having problems transitioning and can put this on Board Docs. Let me see your policy that says where you're going to put this stuff, and then let's see if you did it. And when you did, let's see if this item was on the agenda.
Would we need to be absolutely clear, and when we have a meeting, bring that up as a very specific thing that we're going to do, and that will be sent to the newspaper And it would be in, usually they have a little person to come and do the report of the board meetings. And we could have that, or maybe even pay to have that included in our local newspapers, a publication that each school, each parent would have access to that.
And it could work into a policy, but it's
Yes.
got to be in the policy. I know a
Yes.
board that renewed the contract of its superintendent, and it was challenged. You say, why was it challenged?
It wasn't in the policy.
It was in the newspaper article that went out to everybody. Well, yeah, but where's your policy? What does it say?
Yeah.
Was it there? No, it wasn't where it was supposed to be.
Well, each school has the policy books, so we could always, at our meetings or whatever, that if citizens wished to see, they could go to their local schools, and we could make sure as a board and as the superintendent's office to make sure those policy books are kept up and accessible to every parent or student.
That's why they should be online.
Yes. Well, and online too, but there's so many here in Lincoln County who don't have
Understand.
access to online, to pay for online services.
Sure.
And it would be putting them at a disadvantage. I think we ought to do it at school levels in black and white print, and we ought to do it online for those who have,
So what you need to do is to find your policy on that. I don't have it here with me. See what it says. I'm confident you have a policy that says how notice is going to be given of your agenda and who's going to do it. It usually says the superintendent's office will be responsible for putting hard copies here and there and putting on the website. See what it says. And if you feel like there's a better way to do it or another layer to put on there, then go through your policy process and amend your policy to provide that.
and fix it.
So if I could, we'll probably need to move on from this, but there's probably two aspects of this has to be mentioned. If you're paying for Board Docs and you're not using an aspect, maybe it wasn't understood that you didn't have that feature, but if it looks like you're paying for it, you should use it, because you're wasting taxpayer money if you don't. The other side of that, regardless of what you do use, there was a concern with the brevity of the agenda items. They weren't explicit. It wasn't as comprehensive as it needed to be. And I'll be honest with you, you don't have to reinvent the wheel. If you're not going to use Board Docs, then that's okay. But if you are going to use something internally, we've got a lot of county boards that have outstanding board meeting agendas. Pull up 5 of them and start looking at what are some commonalities. I can direct you in a couple counties to really look at that really do a fantastic job and do it internally. Don't necessarily use a program that functions in that regard. But I do believe the State Department's expectation is your agendas are concise, they're very thorough, they list everything in detail, they're transparent, and if you're using taxpayer money for a program, then you should be using it or eliminating it, one way or the other. Does that make sense? Am I kind of putting that context?
Yeah, just a couple of other points, and then we will move on to the next topic. The test really is, if a person out there in, not just your county, anywhere, is interested in a topic that may come before the board, can they tell by reading your agenda that it's going to be discussed or decided at the upcoming meeting? Or is it hidden behind something like transportation issues and you don't realize you're going to be combining bus routes? Or if a person's really interested in that and would like to see you do it and come to the meeting or watch it or talk to the superintendent or give input to this, can they tell from that agenda that this thing they're interested in is going to be considered? Another point here is, when you do have the right to decide that employees will do things a certain way, or this principal will do this, you want action by employees, your own policies prevent you from being the ones who break that news to the employees. If you look at page 8 in your materials, B, all official communications, policies, and directives of the board that would be of interest and concern to the staff will generally be communicated through the superintendent. The superintendent shall also keep staff members informed of the board's concerns and actions. So if you make a decision about that affects a particular employee or all employees, or a category of employees, or it's a new standard of conduct you want them to behave, you have a new uniform policy, whatever it is, you're not the ones who break the news to the employees. The superintendent has the duty under your policy to do that. And I suspect that was probably written years ago to be sure we didn't have mixed messages coming out to employees. 5 of us were at a meeting, we didn't all hear the same thing. The superintendent's job is to figure out what the board did and make the communication with the employees. And the other one, Jim mentioned Robert's Rules. You do have a policy that requires you to follow Robert's Rules. It's in your handout on page 10. And I think you may remember from the training that Robert's Rules really has 2 sets of rules. It has one that's for most large bodies like conventions and legislatures and so forth. It has in Robert's Rules a section about small bodies like school boards which have only 5 members. And if you get a hold of Robert's Rules, look for the special section on rules for small entities. It has things in it like it's not necessary. If you don't want to, you don't have to require motions to be seconded. Someone can make a motion, you can discuss it and vote on it. There's no breach of Robert's Rules there in a small group because Robert's Rules says you're a small group, you don't need to have a second. You can now you
can.
You can have a local policy or practice of doing that. It's probably a good idea in many cases to see if there's minimum support for something. And there's some other things that are in that section you don't have to do as a board, but you have to follow Robert's Rules subject to those exceptions. And then we kind of got into this. Here's the materials to look at. This happens all the time. Mrs. McGillicuddy comes up in delegations at your board meeting. She brings something to your attention that really does concern you when she says it. And the temptation is to say, well, tell us more about that. And another board member says, well, I don't think that's right. And you're getting into a discussion of something that's not on the agenda. Mm-hmm. And as Jim has said, you cannot even discuss the merits of that at the meeting. This states, this advisory opinion from the Open Meetings Committee that the state legislature set up tells you at pages 60 and 62 that the most you can do in interacting with the individual is if it's not clear what they're saying, you can ask them questions to say, are you talking about, you say the roof's leaking on the school, are you talking about, what school are you talking about? Is it the whole, just enough so that you know what to put on your agenda next time. But if someone says, I just think they're people at the school harassing my daughter, you don't solve that problem here at the board meeting. But something the superintendent would probably intervene at that moment and say, well, under our policies, that's something that comes to me, and I'll meet with Mrs. McGillicuddy after the meeting. But the point here is that just because you have delegations on your agenda doesn't mean that anything that's brought up during delegations now becomes a proper thing to discuss and make a decision about. If it's not already on your agenda, as Jim says, the most you can do is maybe ask a question or two to clarify what the person said, and then make a motion. I move that the agenda of our next meeting have an item where we will discuss the roofing situation at the high school and possibly take action. Then we move on to the next item. And at the next meeting, that'll be on the agenda because the board voted to put it on the agenda. Okay?
Now, I've got a question for you. So ordinarily, who's at your meetings? Who attends your board meetings, besides you guys? Who else?
You're pretty much looking at it.
Mr. Davis?
You're just about looking at it.
And Mrs. Adams, right?
In our finance.
Unless there's some kind of a controversy,
Now,
you know.
who else is attending your board meetings?
Everybody.
Anybody that can pull up a recording
Right.
a day later, a week later, a month later, a year later, and you have eyes on you. And I know when you think about, well, there's only 8 of us, we all know each other, and the formality of this, wow, is that really necessary? It's just us guys, and we're gonna get through the board meeting, and, we handle things. It's a different time, it's a different day, and the expectations are far different. It doesn't matter whether there's 5 people here or 50 people here, you now have an audience on you.
And you do the right thing.
And staying within the protocol. And it might seem really cold and formal, but that's what the expectations are. Because when you step out of that, you're not gonna be able to turn it on.
Yep.
And I worked with a guy who reminded me all the time, it's not a problem until it's
Problem.
And if you've got 100 people, 200 people, they got a crisis going on, can you turn that switch on and it's prim and proper and we're following all the rules? No, because it's not. We are who, consistency, inconsistency as a hobgoblin of little minds. That's a Shakespeare. The only thing I remember about Shakespeare. But I'm very OCD, and I hate to tell you this, guys, but we know it's a reality now. And if I can tell you story after story. A member somewhere in West Virginia made a comment about a personnel matter, about involving a person in their system. And before that board even adjourned that meeting, this person's phone was ringing, and the next thing she did, as soon as that recording was online, she watched it, and you can't walk it back. And those things happen when we lose that formalness. And I know David's looking at me going, but Jim, we're good people, and I believe you. I can see it in your eyes. But it's a problem when you don't make it part of your practice, and you really have to do that. And on top of it, your policy manual says you're going to do it.
Yeah.
So, I'm sorry to interrupt.
No, it's not. In fact, it leads into the next topic, which I'll just go into because we have one slide on it. We talk about you not acting alone in directing people to do things or pretending like the board has said this when you have even if it is, you have no business telling people. You got to tell the superintendent to tell people. A corollary of that is you got to be very careful about representing the board when you're out in public situations. Because the public, again, may understandably think that each individual board member is the font of all knowledge about what the board's done and what people should do. And so, absent action by the board, a vote of the board authorizing one of its members to sit for an interview or to make a statement on the board's behalf, which sometimes you have to, especially in floods and when we have the teacher strikes and things like that, a person should not be out there looking like or saying they're speaking for the board unless the board has told them they can do that. Now, in your county, you have a policy 148. It's in your handout on page 7. You have already deputized your board president to be your spokesperson. So you've already decided that. Now, you can change that policy, but it's probably a pretty good policy. We know who the person is that the press should contact, who can go out and speak on the behalf of the board, whether it's extemporaneously or from a statement. Now, that doesn't mean you can't designate someone else in a situation, but most people don't want to buy trouble, and they're very happy the president will be the spokesperson. But don't take it upon yourself. Now, that doesn't mean that you can't talk to people about your opinion about what's going on at the school board and think, well, I just don't know what the majority of the school board I'm sitting on is thinking when they're doing X, Y, Z. They shouldn't be doing this. That's not right. You don't lose your right to express your opinion, but you better be sure that nobody mistakes your expression of your own opinion as the board's opinion. It's kind of like when you look at social media, Twitter, and or what used to be Twitter, lots of people's profiles say, the opinions I express here are my own, they're not the opinion of my employer. Well, think about that even when you're talking to somebody after church or a group of people that have come to see you about something, or you've been asked to address a group of, the service personnel banquet at the end of the year. You don't have to hide your views. You don't have to muzzle yourself because the board hasn't decided that. You can express your own opinion, but be sure you make it clear. And don't assume that people will know that you're just expressing your own personal opinion. There are people that will hear what they want to hear and think that's what the board's saying. So that's what this whole point's about here. Satisfy yourself that people receiving your message, even a written message, like an editorial or something, that it reflects your personal views and that you are not speaking for the board, unless you're the president. And even the president can express his personal views, but he's got to make it clear, I'm speaking as a board member, not on behalf of the board, or I am speaking as a spokesperson for the board. And that will help to reduce some issues and some problems. Jim, do you have something you want to say about the Ethics Act before I just make a few comments?
Yeah, I mean, it is, how do I put this in context? Of all the things that could go wrong and go wrong badly, it falls under this. We have, and I know Howard's going to get into it, if you haven't ever read this policy, you'll be all right as long as your who follows it. Fill in the blank.
CFO.
Your superintendent. Your CFO's definitely got to follow it, but your superintendent's going to be the person that's responsible. And when you think about all the different things that are tied to finances and making those decisions and those purchases, you have to protect yourself as a board member and make sure that you're staying in that very narrow path. And I know Howard's going to tell you all the laws on it. But when we talk about, county boards that have found themselves, and if you read the papers, well, not the papers, it's online. It used to be, it's only people in your community that heard about some of these things. But now, you wake up in the morning and it's on your phone, and you're saying, oh my gosh, I can't believe that actually occurred. And we know it's happening. And having your board, really not supervising, but holding your superintendent accountable for these things, guys. We saw what just recently happened in Upshur County. We all saw what's just recently, and it's still evolving, what's happened in Boone County. At the end of the day, that's on board's watch. And goodness gracious, you never want to be in a position where you've been party to that. And there's so many different ways that this applies to county boards. I don't know if I've teed that up very well, Howard. It just, honestly, as a superintendent, this made me nervous every day.
Oh, yeah.
Straight and narrow.
There are two main laws, and we're not going to cover them here this evening. We could spend a whole day on it. But you'll see on the slide, we have the pecuniary interest statute, it's called in West Virginia. It's a law that's been on the books for ages. And then we have the Ethics Act that came in 1990, thereabouts, that has ethical standards in it as well. The Ethics Act applies to all public employees in the state. State, local, county, you. The pecuniary interest statute only applies to county level officials like boards of education. It has standards in it that for some reason the legislature's decided not to impose on other public officials. And without going into all the details of what violates the act and what doesn't, I'm going to tell you that if you have even a whiff or a little wiggle in your stomach over something, thinking, should I be involved in this? My daughter's ex-husband works for a company that we're being asked to approve a contract with here this evening. Or I used to have a business that I sold to somebody else, and now they're proposing to do work with the Board of Education. There's a million variations. If you just have, and you're conscientious people, if you just have a sense that there may be an issue, my message to you is get it checked out. Don't decide for yourself that it's not an issue. The difference between these two laws, and it's hard to fully explain, is that the pecuniary interest statute says that if anyone who's in a position to decide the expenditure of board monies on something, and all of you are, right? Your superintendent makes a recommendation at every meeting, your treasurer probably. If anyone affiliated with the school board as an employee or an officer or a board member has a financial interest, directly or indirectly, in something the board's being asked to do, the board can't do it. Think what I just said. If one of you has a financial interest, directly or indirectly, that you can influence if you wanted to as a board member, the board can't enter into that contract. The board can't do it. You can't say, well, I'm going to leave the room, recuse myself, we call it, and the rest of you vote on it. No. The board cannot enter into a contract or an agreement to pay money to anyone if any board member has a direct or indirect financial interest in the outcome. Now, it's obvious when it's your spouse that has the company or a dependent child. But what if a company an individual that's in business for themselves proposes to do something for the board, mow lawns in the summer as a grounds people, and anybody on the board, maybe they owe money to you. You lent them money to help them out in a tough time. Well, now you're going to benefit if they get this contract, aren't you? Even though you're not affiliated with their company or their business, you will benefit, arguably, if they can make money during the summer. They'll more likely to repay what they owe you, right?
Oh,
And you're in a position, directly or indirectly, to influence
approve
that.
or not.
So whether you exercise that influence or not, which you wouldn't, whether you leave the room or not, under the pecuniary interest statute, the board can have nothing to do with it. We had a board where one member had a conflict of interest like that, and the board went ahead and voted to do it. And the board member who had the interest got kicked off the board. The board members who voted for it, knowing that that person had the interest, got kicked off the board too when the Supreme Court upheld it. So even though you're not the one that has the ability to control something that could directly benefit you financially,
You know about it.
but you know that that's true of one of your other board members, in these particular instances, the board cannot enter into the arrangement. Now, there are all kinds of exceptions to that, but I don't want to get into those and have you lose the message that it isn't just enough that the board member who has the direct or indirect interest and could influence this leaves the room when the others vote. Under the pecuniary interest statute, the whole board is prohibited from doing it. That's how serious this is. And it's a crime for the person that has the direct or indirect financial interest, even if they didn't vote, but the board did. It's a crime, and there's all kinds of consequences.
Howard, there's an item on the list of things that we needed to cover and cut somewhat of a scenario. So, do you guys believe there's any secrets in Lincoln County?
Any?
I'm sorry, I didn't
Are
hear.
there any secrets?
Not
in
many.
Lincoln County?
Not many.
Any secrets?
Probably not.
Not many.
There aren't even secrets in the state of West Virginia. Somebody's gonna tell somebody, right? And this may not have anything to do with any one of you guys benefiting or a family member, and you look at that pecuniary, you're sitting there going, I'm not really sure why that's on the list. But if you are aware of something that's going on in the school system somewhere, it could be as simple as this. You got somebody that works in the system, and they own a catering business. That's a side business. And they're doing all the catering for all the sports banquets and all the things at the school. Well, that's a violation of the Pecuniary Interest Act. You're knowing about it, and God forbid you're approving an expenditure for it. If it ever becomes a complaint filed with the Ethics Commission, in some regard, if you knew about it and you're also approving the expenditures, you're culpable for that.
But what about if I'm a principal of the high school and I approve that and I know about it? Then I'm in trouble.
Yes, ma'am.
We're just not doing a good enough job of telling our employees stuff like that.
So.
Because they don't know that stuff. I didn't know that stuff.
Well, they need to know that.
Yeah, I guess they sure do.
The other side of this is the good old boy system of getting things done. You know, there's such a thing as called stringing. And I've seen it where you got a project, we really don't have enough money for this, we bid this out, we're gonna get Fred to come over here and do this side of it. And you all know about it because you just paid the bill to pay for all that concrete.
Yeah.
Guess what? That's a problem. And again, I go back to, you follow this thing, you avoid that thing. And the days of relying on, and you guys have an excess levy?
We do.
Is it a strong excess levy? Pretty good?
Yeah, pretty
You
good.
have a lot of carryover, unrestricted funds, don't need the amount, you're in good shape financially?
Fair.
Do you rely on a lot of volunteer work and things in the community?
Lord, yes.
Okay, she's honest, and she's quick about that, you know?
Well,
She didn't even take a
do.
deep breath on that, did you?
Well, you have to.
Well, you've got to be very, very careful.
You do.
Things aren't built to code. I just tore up a football field in the community. There were water lines, power lines. We were blowing stuff up every 2 hours, getting the football ready, field prep for turf. And honest to Pete, nobody knew where all the water lines were. Nobody knew where the electrical system was underneath that. Because what? They looked and they said, well, we can go right through here. And nobody knew it was there. Something blows up and you got volunteers working down there, guess who's liable for that?
Yeah.
Somebody gets hurt, and you know that's gonna be a problem. Then the other thing is, if it's not the code, it's gonna be a problem. If you don't go through this process, the days of being able to rely on a lot of volunteer work, guys, it puts the board in jeopardy, especially when you're looking at liability. And if they don't have liability coverage and they do something, they got somebody down there working with them, guess who's gonna be held for the ticket? You guys are. And if you say, well, we didn't know,
Not good.
not in Lincoln County, not in West Virginia.
Yeah, we need to
Maybe if you
definitely
live in-
do that with the principals so that they know as head of the school that they can't, they just can't do that anymore. And I don't know how they'll do things.
Now we just come up with a future discussion for a board meeting agenda, and maybe a direction for the superintendent to provide training to
That's right.
all school leadership
Yes.
around what can we do, can we not do outside this scope.
And you
May
have-
not, but I think it's worth mentioning.
You already have policies that maybe aren't being followed that dictate how volunteer services can be received and allowed. This board has to vote on the particular volunteers and approve them to do whatever it is they're going to do. There are all kinds of other requirements, but they're in your policies. They're already there. So you might want to look at them. Going back to this, there are some things that under the pecuniary interest statute the board just can't do. There are other things that it doesn't prohibit, but the Ethics Act does. And under the Ethics Act, if you violate something do something that violates the Ethics Act but not the pecuniary interest statute, then oftentimes the person who has the conflict of interest can leave the room and the board can vote. And a good example would be that one of your sons applies for a job that's posted and they're one of the candidates for the job. Under the Ethics Act, you don't have to show that you might get any money at all. You are prohibited from using your position to help certain members of your family, your extended and your immediate family. You can recuse yourself from the room whenever any discussion is made about filling that position, even though maybe your son is the worst applicant and isn't going to be recommended. You still can't be in the room even when they're discussing the other candidates because it could end up affecting the outcome. So I guess the message I'm giving you is that a violation's a violation, but in some cases, it keeps the whole board from doing something. In other cases, the board may be able to do it, but you may have to protect yourself by leaving the room and not even discussing the matter with the board, much less vote on it. And a primary interest, as Jim has said, is conflicts of interest between board members and something the board's going to do. It doesn't have to be financial. You're not allowed to use your position to personal benefit, okay? So it could be you feel really good if your son gets a job. I'm not going to gain money if they get the job, but it's my family member and it's good. You're benefiting a member of the family. I just want to sensitize you that in the Ethics Act and in the Pecuniary Interest Statute, depending upon what the conflict of interest is and who's going to benefit, let's say the board's going to enter into it's being asked to enter into a contract with a business that your spouse owns, that violates the Pecuniary Interest Statute. It wouldn't violate the Pecuniary Interest Statute if the board's about to enter into a contract with your spouse, well, not your spouse, but a cousin of yours. That doesn't violate the Pecuniary Interest Statute. It's about spouses, dependent children, and other dependent persons that rely on the board member, the person who borrowed the money from you and can pay it back. Under the Ethics Act, they tend to talk in broader groups. And some things you can't do if they will benefit your immediate family, your spouse, someone living with you as a spouse, even though you're not married, dependent children, dependent grandchildren, dependent parents. Other laws say that you got to be careful that you're not involved in something where the benefit could go to a relative, and they define that as a grandparent, a parent, a sibling, a child, a grandchild, an in-law. Again, we can't go over all that. I just want to impress upon you, this is not an easy call to make. And I encourage you just to, and your finance department's probably already aware of who your spouses are and who your children are, and probably protect you by saying, hey, boop, this is Mr. Sufer's son-in-law that's applying for this. Let's be sure it's okay. But you need to think through, if something, you look at it and you think, I know my grandmother may be wanting to be a volunteer. Can we approve that, or is that a conflict of interest? My point is, ask the question. Don't assume you know the answer. Some of these conflicts are indirect, but you're still held accountable if you don't follow the rule. Here's an example. Ethical questions aren't easily recognized. The committee that the legislature appoints, or commission, the Ethics Commission, has looked at some situations, and their job is to interpret the law and tell us how to follow it, what we can and can't do. They have decided that if you as a board member, we're not talking money, you get confidential information, maybe in an executive session, a personnel matter or something. If you get confidential information about a student or anybody else, as because you're a board member, you cannot use that situation to benefit yourself or group of relatives. So you got to be careful about what you say when you're outside of a board meeting. You may have learned something in there that you think this will remove the cloud over my grandchild's head, this rumor that's out in the community. I just found out that Bobby Smith said that he's the one who brought the weapon to school, not my grandson. I'm going to tell people that. You can't do that. That's confidential information that you can't use to benefit yourself or, in many cases, your extended family. That's not that's no money involved there, so you wouldn't think that's even an Ethics Act issue. Another one is where one of you is on the Board of Education, but you're also on the board of a nonprofit, let's say the YMCA or something like that, and the school board's being asked to enter into an agreement with the YMCA to pay them monthly fees so your kids can go over there and swim, the school children can swim. You think, oh my goodness, I'm on the board of the YMCA that's offering to do this. I'm on the board of Education that's going to vote whether to do this. I probably have a problem here. Ethics Commission says you don't. You don't, because it's a nonprofit organization. You're not paid to be on the board of the YMCA. Typically, board members of nonprofits, you're all probably on such boards. I am too. I don't get paid. So you're not gaining anything, whether the YMCA enters into an agreement with the school board or not. It doesn't have any financial impact on you. It is a nonprofit, and the school board is too, so it's okay. But intuitively, that seems like maybe that's a problem. So the last one here, I've given you some things in the materials you can follow up on. That's why I put those things on the slides where the pages where you'll find them. The last one is a question was, can a board member get a key to the gymnasium, and then on the weekend when his family's in town or a group of guys gets together, no one's using the gymnasium, just go down and let everybody in and use the gymnasium, clean up, and then leave? Absolutely not. It says you're using your position as a board member, where you can get a key and you can walk in there and no one's going to question you, to use taxpayers' facilities to benefit you and your friends. So I cite those examples because they're not intuitive that would necessarily be a violation or that it is a violation. And what I always recommend is, if you have any question at all, get advice. And in my experience, and I do a lot of work with different agencies in state government, there is no agency more responsive when you make a phone call than the Ethics Commission. Part of their job is to give advice confidentially to people who call in and say, hey, my board's about to consider a contract with the YMCA so our kids can swim in the pool. I'm on the board of the YMCA. Is that a problem? They'll tell you. And they're expert in this stuff. They've been through hundreds of these. And if you ask them to, they'll even give you a written opinion saying that it does or doesn't violate the Ethics Act or the pecuniary interest statute. And what's nice about that is the legislature wants people to call the Ethics Commission and get their advice and follow it. The law says that if you get a written opinion from the Ethics Commission saying that what you propose to do is okay, and you follow their advice, even if they're wrong, if somebody goes to court and convinces a judge the Ethics Commission was wrong, you have immunity from being sued or being found liable for what happened because in good faith, you followed the advice of the Ethics Commission. And it goes one step further. The Ethics Commission puts all its opinions online. They get rid of the name of whoever requested it, and if it says what county it is or something, they'll get rid of it so nobody can tell you're the one that requested the written opinion. But when they send you an opinion, they post it online. And if you find one of their opinions about something that you have a question about that you're about to do, and it's exactly the same as what, it's maybe another county with a YMCA lease, and they find that opinion and it says it's okay, and they follow it in good faith, they have immunity. Yeah. So they really want to encourage you to check with them, see what's on their website, call them up. And again, I've never been put on hold when I've called there. I've never had somebody say they'll have to call you back. I don't know how they do it. Someone is on the phone and says, well, let me ask you a few questions. They want to know a little bit more about the matter. And then they'll tell me. And they keep a record of what they told you. And if you then also request a written opinion, they'll say, well, in writing, send me a written request, and we'll have the Ethics Commission, which meets every month, consider your question, and we will give you a written answer after the next meeting. And the beauty of it is you have immunity, even if they're wrong. And there are sometimes people in the community that say, you shouldn't be doing this. You can't do it. It violates the Ethics Act. It's great to have an ethics interpretation from the Ethics Commission that says, yes, you can, and if you follow these steps and I follow them, and that you can tell people about that. That's not secret. Uh-huh. You can say, they said it's okay for me to do this. Jim, you've gotten into this and talking about the volunteer groups and the press box and the lines under the football field and all, but this is fairly common. Thank God we have boosters groups, especially for athletics, but also for some of our other extracurricular programs. They want to raise money to fund trips by the group to compete or to be in the parade at Thanksgiving Day parade in New York City, or they want to have a fundraiser to put new curtains on the stage, or Lord knows what. And you're exactly right. You could not function without your support groups and your booster groups. And when Jim held this up, this policy, beginning at page, I've got it on here somewhere, 25, has all the rules that govern that.
Yeah, you couldn't run a high school without, boosters clubs and different things. There's just no way. There's no money.
So we live in a different time. Board approvals of these things, these activities, who are our volunteers? I don't know what your policy is. Does it require a criminal background check? Do they have to fill out a form? And they can't function in your schools until you've taken board action, board approval. I think that's a critical piece of this. The other side of that is if they are functioning, there's certain things folks are allowed to do when they volunteer. If they're functioning, going to do something outside of that normal scope. Howard goes and reads at a school once a week, am I right? Mm-hmm. He's a volunteer in that school system. That's great. But now if he wants to go in and, I don't know, paint the locker rooms, that's something different. Now, how's that going to happen? I just think you need to make sure that you guys have that, institutional control of what's happening in your system.
Jim,
and again, it comes back to your superintendent first, and then you guys being able to approve those things and those individuals do board action, whether it's a consent item.
Our policy on that, I'm not even sure if we have one or what it consists of, but can the board make a policy that gives that authority to the superintendent to make those decisions instead of each one of those coming before us?
There's a distinction here. Your BRIM insurance, which covers you if a volunteer gets hurt or they hurt somebody else, It will protect you against lawsuits or defend you in lawsuits brought by a person who claims your volunteer did something wrong, only if the minutes of a board meeting show
Reflect that.
that person's name was approved to be a volunteer.
Okay.
If they were not, and they run over somebody on the way to a fundraiser, or it's claimed that they hurt a child or something, and there's a lawsuit, Brim will say, show us the minutes where you approved this person as a volunteer in your school system, and if not, then they're not covered by the board's insurance. So that's the main reason that you want to be sure their name appears in the matters.
So
And-
who would have to pay in that? The school itself? or
No, the Board of
The
Education.
Board of Education?
Everything is the Board of Education.
Okay. So
You
we're
can't
gonna
sue a
have to do it
school.
one way or the other.
Do you know that you can't, nobody can sue a school? They can try,
But
but
they
never
can't.
work, because schools are just buildings.
Yeah.
The Board of Education.
You ever seen the big globes up on top of the old power poles, and folks love to get hold of those things because for some reason there's a value, and never quite understood that. But in a hypothetical situation, school property condemned, getting ready to be demoed, fencing all the way around says stay out. You hypothetically believe all the power's shut off to the building, but that pole is on your property. Outside that fence, if somebody goes up there and reaches up there, climbs up that pole, grabs those two, what do they call it? I don't even know what they're called. Globes? I don't know what you call them.
And gets electrocuted?
And guess what? You don't have proper signage, wasn't fenced off. Guess who's liable?
I expect I know.
Guess who's not paying?
Yes.
Guess who's not paying? For him. I mean, there's certain things that you gotta be careful about. I mean, that's the most extreme, in my career, that's the most extreme circumstance. And when you talk about a lesson learned, but when you look at this, again, it's about institutional control. It
Yeah.
starts with your school administration, your central office administration, your superintendent, and ultimately these things come to you.
The school board.
You take board action, and you have a level of protection there.
So like we're building the Duval Middle School. Say just, for instance, somebody goes on that property and gets hurt doing whatever. Is that contractor or is that the board? Who's responsible in that area? If they have, proper fencing, signage.
If somebody comes onto your property and is hurt, and claims that there was negligence involved, then the board will be sued. And Brim will defend you, unless what they're complaining about is solely the act of a volunteer. Or the volunteer themselves might try to sue you. If they get hurt, they're helping and something falls off the ceiling and crushes them. The board can be sued.
Contractor though. Is that still the same principle?
He's talking about a
They're gonna sue everybody.
That's it. We're talking here about volunteers, not
That just-
hired contractors, right?
I just-
There's a whole set of laws about whether an independent contractor is liable for their own damages. And in those cases, the general rule is that you hire a plumbing company to come to your house and do something. They're an independent contractor. If they run over somebody on their way to get there, that's on them, right? If the board enters into a contract with an independent contractor to do something, the same rule applies, except a clever plaintiff will argue in a lawsuit, well, yeah, I know the independent contractor is responsible for this, but we can show the board engaged this independent contractor improperly. It wasn't on the agenda. They should have taken bids and they didn't. They should have realized that they had prior problems. And so that often happens is that they're not suing you because they claim you did this, but that you enabled somebody to do it that you shouldn't have because you didn't follow a proper process.
But I will tell you, when I was in McDowell, right the year before I got there, Howard probably remembers the story. They were moving the mountainside, was getting ready to build Riverview High School, and a boulder came off of the mountain, landed on a person in a vehicle, and it killed them. And initially, everybody gets sued. The school system, the contractor, the folks that were doing the demolition work on the hillside. But ultimately then, as Howard said, that's all gonna get weeded out. So in your construction site for that school, I guarantee in your I can't guarantee, he's gonna yell at me when I am, he won't yell at me. There are no guarantees. But I'm fairly confident that there's a clause in your contract that says who's in control of that property during that construction.
But it wouldn't hurt for us to look.
you know?
We have looked.
Oh, good, that's
He
all I
already
need
had
to know.
his.
Yeah, and you have some duty when you're choosing contractors to know something about them and their ability. Usually it's the lowest responsible party that bids and gets it. Let's go back specifically to the issue of your boosters and your community organizations. We just talked about you have to have approval of volunteers that are in your schools. This policy, which is the other handout, and a bunch of other laws make it clear that nobody can raise funds in the name of your school unless the board has approved them to do so. So you might have a Lions Club that commendably wants to raise funds for some project at the school. They can't do that unless their name, their organization, and the fundraiser is on a board agenda. And the board has approved that, said, we approve the Lions Club trying to raise funds in our name. And that, you'll see that spelled out beginning on page 29 of that other handout. This handout is about how we handle financial affairs at the school level. And the first part of it is, it's interesting reading, but you don't need to read it up until page 29, is about the day-to-day financial operations of the school system, who collects the lunch money, how often is it deposited in the bank, all that stuff. But beginning at page 29, they talk specifically about school support organizations and boosters organizations. And they have all kinds of requirements. I've just kind of wanted to hint at some of these here. You can read the requirements, but they have requirements that you must satisfy. You can't say, well, we didn't know we had to do that, or about approving fundraisers. These groups that raise funds in the name of your school have to meet certain requirements. They have to have bylaws. They have to have a board of directors. They have to have certain officers. And you'll see that written in this state board policy. And I'll break the surprise at the end. It's also in your policy manual. You have what's AG? Is that administrative procedure as opposed to?
Guidelines.
Okay. And they have that's the guidelines in your school system. You require bylaws. You require a board of directors. You require officers. In fact, your policy requires most of these things that you'll find in 1224.1. There are regulations as to the bank accounts they have. Are they at the school, or are they their own bank accounts? And if they're their own bank accounts, what requirements do they have to make, or else we're not going to let them raise funds in the name of the school. How many times in a year's time, do you read in the paper, in the media, about some volunteer fire department or some other organization that all of a sudden they're missing $70,000 and so-and-so's resigned? And these booster organizations do incredible work that we have to have done through these organizations. We would never get these things done otherwise. It's like the athletic facilities we build. And but they're also, if there are people that are unscrupulous and somehow work their way in there aren't all the controls that we have. And we don't have perfect controls, but they don't have all the controls we have for monies in the school system. So that's why they impose these conditions. There are requirements about what they do when they pay for things. If they're involved in concession sales, there are reports that they have to file after every event showing the goods that were purchased, that were sold, and explain any differences. After every fundraiser that the board has approved, a group that raised funds in the name of the school must produce a profit and loss statement. And there's actually a form for that statement in that other handout, the policy. They have to give receipts to people. They have to reconcile their bank accounts. Annually, every group, booster and other support organization that raises funds in the name of the school has to produce a financial report and give it to the principal, who has to give it to the superintendent. They have to be registered as a business in certain cases, and on and on. They have to retain their records. Now that seems like a lot, and I can understand a volunteer group saying, we're not going through all that. We just want to raise money for you. But we also would like to not have to follow seniority sometimes and just hire the most qualified person. And there are all kinds of things the school boards have to do because we're dealing with taxpayer funds, and we have to be very careful that we don't play favorites and that we do things objectively. And so while these things may seem onerous, they're absolutely required. Now, just a few related concerns here about these groups. There are regulations that have to be followed when these groups use your facilities. You can't just have an informal process where the principal says, nah, we're not using the gym Saturday afternoon. You have somebody that'll clean up, yeah, you can go ahead and use it. You have a policy, I've cited it here. Policy 7510 has an approval procedure. Most importantly, there is a requirement that every group that uses your facilities have liability insurance and prove to you that they have it, that would protect the board if anything happens at that event during their use of those facilities that causes damages. They also have to agree to indemnify the board if the board is sued because of something this group did when they were there and is found liable to another party. There's no exception to that in the law. And in your policies, your own policies reflect that. So we want to be sure we follow that. And again, it may seem like, who's going to make the junior women's club go out and get a liability insurance policy for $1 million, which is the amount that the statute, I've given you the statute here too, requires.
Howard, I have a question. You guys have a facility request form?
We do.
And it goes through board action?
It does.
Yeah, and they have a board policy that prioritizes things. First of all, any educational need to the school system that requires use of the gym, for example, or the auditorium, takes priority over anything else. And then there's a list of 6 or 7 different things in order that if 2 groups want to use it at the same time, this is the one that will get priority. And it's already spelled out in your policies, which is why I said at the beginning, on the one hand, sometimes we don't like to have to follow our policies, but you are blessed in this county with policies that address every issue I've talked about, or it's already addressed in the policies. You just need to follow them, and you're probably more likely than not to stay out of trouble.
So I'm not gonna ask you guys, but I would tell you, if we surveyed 55 counties, I wouldn't be surprised if there aren't some that either would claim they're not aware of the liability requirements, the insurance, or if they opt not to hold folks accountable for those. You just gotta remember, if you board approve them, there's no backing out after the fact. If something happens and you say, well, what could happen? Well, if there's, if they do something, and it's on your property, and they don't have insurance, you're next up. And you gotta know, folks, everybody understands what BRIM stands for in the state. And those lawsuits are costly. And then the next thing is, your BRIM coverage, that premium keeps climbing. And I've dealt with this. It's tough for a lot of organizations to come up with. And actually, when you look at how much it costs, in most cases, it's not cheap. Where it's gonna be expensive is your Pee Wee football team that uses your football stadium for games. And keep in mind, you're also looking at the people in the bleachers and all those other things that go on at ball games. There's a lot of responsibility. So making sure that, and you've got to have a copy of that policy when they submit that application. Howard, do you recommend board approval for use of facilities?
I think if you have a good enough policy, I think it's fine. And for example, the superintendent or designee is responsible for implementing the policy, and they do it in accordance with the policy, I think that's sufficient. But if they deviate in any way from it, then that doesn't protect the board. I've drawn a separate thing here about businesses that want to use the school property. So we're not talking about nonprofit community organizations. First time I ran into this was at a school, public school near the interstate, and a contractor was hired to resurface the interstate and needed someplace to park their equipment overnight. So they approached the school board about leasing the parking lot next to the school. They would only be using it, a portion of it during the summer, but they would use it every day, and they paid the board money. And they weren't going to harm the parking lot, but they agreed they'd take care of any damages. We were asked about it. We looked into it. The board could not do that. You cannot allow a profit-making business to use public premises. We have people all the time that want to use the gymnasium to sell their wares. You cannot let groups use board facilities to help generate a profit. Now, that's different than allowing them to use the gym for a a fundraiser and they sell tickets, these regulations that we just talked about talk about how, and those are nonprofit groups that are using those. But if I'm just an entrepreneur.
That's nonprofit groups other than our school itself.
Yeah, yeah.
Okay.
But if I'm just an entrepreneur and I've got a friend who knows some celebrity and I say, hey, I can get them to come do a concert at the football field and we can sell tickets and VIP things and all, and it's all just going to me. We can't do that.
Howard, what if it's a craft show? You have a craft, the Boosters organization at the high school sponsors a craft sale, not a show. A lot of schools I've seen do
Yeah.
that, and their gymnasium, and their people are in there to make a profit, and the Boosters gets 10% of the profit.
Yeah, that may qualify as a use of the facilities by the community group, because in the end,
It goes back to.
that's how they're raising their money to pay to you. But there could be differences in the arrangement that would throw that over if it's a subterfuge, if somebody wants to sell their wares and at this gymnasium and with all the parking or do whatever they're doing, and they go looking for some community group that'll agree to give 1% of their proceeds to the school district, we got to be careful. But typically this comes up in a more direct way. Somebody wants to rent one of our unused buildings. And there are ways that can be done, but we don't just do it informally.
I brought that up for Robert, because he, in the beginning of the training, he was sitting up here going, now he's sitting back and he's really going, I mean, those wheels are turning, am I right or wrong?
Yeah, it's a lot. It's a
Yeah,
lot.
There's a lot here, isn't there? And goodness gracious, to find somebody who gets it right every time, good for them. And I'll go back to Howard keeps that saying, ask the questions. And these are productive questions to ask in a board meeting. You see an approval in a consent item, and you're sitting there going, well, when that training I heard, that's a good time to ask a question. And if we don't get the answer we need, then you might want to table that item
Yeah.
until we get some more information.
So if you're not sure, there are resources available to get.
The Ethics Commission's a great one. The board itself can request legal advice, but don't any one of you call me and say, hey, this come up before the board and I'm concerned about this. In fact, there's some other board member that says it's not a problem. Can you talk to me about it? I represent the board. I'll probably have to send you a bill personally, which I won't do. I'll stop you before we get that far. But it wouldn't be bad if you got a question to have you're talking about something, and one of these questions comes up, you can say, I move that we ask the superintendent to get some legal advice or some advice from authorities and bring it to us at the next meeting.
I will tell you, our school board manual, which is online, it's not a paper copy. Every time I get a question, like some of this stuff we're doing today, I pose it in a question and it falls in a chapter somewhere, there's 20 chapters.
An answer to it.
And it's in a format that you can kind of look at and say, yeah, this applies. And if you don't, call me.
Okay.
And I'll see if I can't get that answer for you. And if I can't get, if it's legal advice, I can't give it to you. But if I can get you to 99.9% positive, then that's a win-win.
Yeah.
That helps us as an association, as a collective group of school boards, and at the same time, helps you get some sense of security.
Yeah, because there's so many of the other schools that have to do that. You know, they have to have some money to support some of the activities they have. And it just always probably needs to come before this board to cover the insurance.
You know, one of the biggest gifts volunteers or individuals in the community can give a school board is say, hey, we're going to build a athletic training facility in the end zone at the high school for you. Or I'm not speaking out of school. I would never divulge a client confidence, but it's been in the paper. We had a county that has a big stadium, and they couldn't afford to reinforce the seats. So a boosters group said, we'll take care of it. It's going to cost
Millions.
7 figures, but we'll take care of it. And there came a time when the people who were all excited about that weren't anymore and weren't paying for it. We had contractors that were looking for money. We had a boosters group that agreed to put artificial turf on a high school's football field. And they took out a loan at a bank in the community. What bank's going to turn down a loan to the boosters for the high school football field, right? Well, there came a time when the people who were all excited about that, their kids had graduated, weren't there anymore, and nobody was making payments on the loan. Now we got a bank saying, you know, we're going to take you know, there's a market for that artificial turf. You can take it up and sell it. The board was in a quandary. They didn't want to stiff the bank, but they didn't agree to do this. You need to be really careful, and Jim's given you some examples of wealthy donors or people not necessarily wealthy, but they're good-hearted, wanting to do facilities work on a volunteer basis. And I've given you only two, Jim's given you a couple of other, but 2 reasons here while we worry about it. One is liability for any defects in the work or damages or unpaid bills. Here it is on your property, it's yours. Once it's on the property, it's not theirs, it's yours. Once it's attached to the property, it's yours, whether they want it to be or not. Also, we had a case up at West Virginia University a number of years ago where they wanted to build a new service building of some sort, I guess, for maintenance services and so forth. And for whatever reason, they decided they couldn't afford to do it. If they spend public money to do it, they have to take competitive bids, right? And at that time, they had to pay certain wage scales, prevailing wage scales to all the workers. The West Virginia University Foundation, which is where people donate money, said, "Hey, guess what? We'll build it for you. We'll be the ones who get the contractors. We don't have to take competitive bids. And we're the ones who will be doing this, so we don't have to pay the prevailing wage." And they did. And they entered into agreements to do it. And they were sued by the construction workers union, the trades union, saying, wait a second, you're just doing indirectly what you're not allowed to do directly. If you were building this WVU with your own money, directly contracting with these people, you'd have to do competitive bidding and you'd have to pay prevailing wage. You're just trying to, a subterfuge to get around it. And our Supreme Court, in its opinion, says that you can't do that as a public body. Now, West Virginia University got by with it because by the time the case was decided, the building was already built. So it was a little late to say, well, you got to take bids. But the Supreme Court went on and said, because this question might come up again in the future, let us tell you a few things. And one of them was, don't use this as a way to get around avoiding your obligations as a public entity and spending public money. We're going to close by talking about something the superintendent's referred to, or still called Jim a superintendent. He was one. And in my mind, he still is one sometimes. But he's really come over to the school board side since he got this job with the School Board Association. His eyes have been opened. He crossed the street. He's over here with us. And this is, everything we've talked about here has some dimension that comes back to the board's relationship with the superintendent, who by law, it says right in the law, the superintendent is the CEO of the Board of Education, a term we usually associate with private corporations, but they use that language in the law. Jim, you want to say a few words?
If you just look across the state, we're seeing, like I said, facilities, personnel, student achievement, consistency in how they operate. It's when the board and the superintendent are working harmoniously. And that all starts with communication. And I don't know how you guys function, but one of the challenges, and this comes back to some of the other things that's already been mentioned, when you guys start usurping the superintendent's authority, you're making decisions, as in, well, this person's getting that job, and we're gonna do this at this field and this, and it's happening outside a board meeting. Folks they're going to say, well, I don't have to go to the superintendent, I'm just going to Robert, or I'm just gonna go to Sheila. That's when we start seeing wheels coming off the bus. The statute's written the way it is, and it does rely on the superintendent. But it's a two-way street. They also have superintendents, if I had to look at it differently, because I've seen where it's not working well. And superintendents have to have that ability to communicate with the board. You guys don't like surprises, and it's harder to fix something after the fact. And there has to be an expectation that we are following the rules, we are following the policies. Probably if there's anything, a takeaway today, I didn't realize how new you guys were, and my apologies. I should have known that coming in today. You know, coming to our trainings, not everybody, you know, they're like, oh, I gotta do this. The Mountaineers are playing Saturday. You know, well, we can only work around so many Mountaineer games for the fall conference or whatever's happening. But I have to tell you, and I'd say this whether Howard's staying here today, we've really tried to make sure our trainings are purposeful. It's also a way for you guys to network with your superintendent. And that time you spend for a day and a half, twice a year coming to our conferences, it really helps with that dialogue. And the other part of it is, you're both hearing the same thing. Frank might attest to this, maybe not, but I know when I went to superintendent's trainings, it was about the school system, the school. Never really talked about work relationships and that type of, those things, how we make things work well for the system. And really it comes down to the six of you guys making that happen. It's critical. It really is. And right now, we're seeing some challenges. Howard and I've talked, 2 years ago, there were 17 new superintendents, 14 brand new, 3 that were interims. I think last year we hired 5 or 6, 7 maybe?
At least, yeah.
This year we're looking at 9. So that's over probably 70% of all new superintendents turned over in the last 3 years. And every 2 years, we're turning over 60, 70 board members. And here you guys are, basically your whole board in the last 3 years. So there's going to be some growing pains. My word of encouragement is ask questions. I had a board member email me last night at 2 in the morning. I've had board members getting out of a meeting at 11 o'clock at night. My phone's ringing, text message coming at 11:15. And I tell folks it's going to be live and streamed. I'll answer your call, answer your text message, unless I'm in church or in the restroom. Other than that, I'll get back to you. I kind of pride myself in that as a superintendent. But you guys can do great things here. You really can. I don't know Frank real well, but I know, so I can see it in his eyes. His heart's in the right place. He wants to do a good job for you guys.
Yeah.
And you empower him, he's going to help you get the job done. Then again, and I've been there too, got to hold him accountable. Frank's saying, just want too much today, right, Frank?
Oh, it's all good.
I know.
And a point we make here, it's helpful. The superintendent's the only person who works for you who isn't just an employee. He's also well, actually, there's 2 of you. The treasurer and the superintendent are public officers. They have duties, whether you want them to exercise them or not. You can't keep them from doing it, and they can't give them up to you. Just like the governor has certain duties and the mayor has certain duties. And we've given you in the materials, and you can see this, how to find them here, the basic state laws that spell out what the superintendent's duties are. And you have a whopper of a policy, your board policy 1230 on page 14. It has 2 pages of bullet points of what this board, as a corporation, has charged its superintendent with doing. And having charged him with doing it, you can't take it back unless you amend the policy and it's permissible. So sometimes it's good to be reminded of everything that either the state law or your own policy requires the superintendent to do. And by policy, you can allocate some of your own responsibilities to the superintendent, and if you do, and it's lawful, then he has to respect them. He's the one person you can say was disobedient, was insubordinate, if the board as a board lawfully directed the superintendent to do something and the superintendent does not. Here's finally, I went through your policy manual, and here's some duties you've assigned to the superintendent that really ties all of this together. The superintendent, as we've already seen, is the communication channel between the Board of Education and every employee in the system. You saw that, we read that provision of your own policy that says that. The superintendent is where you are to send public complaints that you get, either about people or policies or anything in the school system. You've decided that's the job of your superintendent. And by coming to work here, he agreed to that. You have said that the superintendent is responsible for bringing to the board developments that would require new or modified policies and any changes in your policies. It specifically says that the superintendent's the one who is responsible for that. You also use the word latitude in saying that the superintendent has latitude in performing the duty of implementing our policies. He's the CEO. We will adopt policies. We'll decide how things are going to happen in the school system or not. But then the superintendent is to enforce our policies, and he has some leeway in how he does that. You depend upon his expertise and his judgment. He has to carry out the policies, but he has some latitude in doing that. And I've never seen this last one. It's probably been in policies and I haven't paid attention. This is the exact language of Policy 1210. The superintendent is the primary professional advisor to the board. And I don't think you'd ever be in a position where you'd want to ignore your superintendent's opinion on something that has to do with professional matters. You pay the superintendent well. You look forward to their advice, even in a situation where you don't have to wait for a superintendent's recommendation to do something. And there are some of those. We've given you a little memo on page 3 of your materials. Even in those cases, you're crazy not to say, well, superintendent, I know we don't need your recommendation to do this, but what do you recommend? And you may not do it, but it enriches your decision. I want to close by just sharing with you something that gladdened my heart recently. Jim said I read at a school. I read every Thursday morning to a split second, third grade class at an elementary school in Kanawha County. And it's the highlight of my week. It really is. I return to the office no matter what cases I'm trying, what losses we've had. But I'm in that classroom with those kids. I just come away so impressed every time.
You really remember what it's all about, don't you?
You do,
Yeah.
and they're so bright. And,
They are.
And it's second and third grade, you know, they're not as cynical as they will be later. They're still devilish, but I typically am dressed like this when I go there because that's the beginning of my day. I read at 8 o'clock in the morning, and I never thought anything about that. So I went to the school just before Christmas on Thursday, which is when I read, and I get buzzed in and I sign in the office. I'm an approved volunteer. I've had my background check and everything, and I go down the steps I usually do down to this classroom, and I see kids in the hallway from time to time, or teachers, and some kid passed me apparently as I was going down the steps, and he was coming up. I paid no attention. I was probably looking at my book, getting ready to read, and I got down to the classroom. I had a really good session reading, and I came out, and the principal was outside the room, and she said, when you came down those steps this morning, did you happen to see a young first grader coming up the steps? I thought, oh my God, you know, what's happened? I said, no, I didn't. She said, well, I just have to tell you what happened. Apparently after he passed you on the steps, he came running into the principal's office saying, Mrs. So-and-so, Mrs. So-and-so, the president's in the building, the president's in the building. And she said, how do you know? She says, I could tell he's got on a suit and a tie and everything. And I thought, you know, how did that come about? It's probably a kid who doesn't see people in suits all the time. Maybe his parents don't have a job like that, and you know, a lot of people don't dress up for church anymore. And maybe he has seen the president on TV or something. It's before the election, it was. And I just thought that was cute. And to this day, they call me Mr. President when I come to the school, even the staff. I told my wife about it, thinking she would think that was really cute. She said, why do you think they do that? And I said, well, I think it's wearing the suit. And she said, no, you walk like Biden. You talked about volunteers. I love it. It's really great. I think Jim and I both admire you for sitting through this evening. I could tell you were listening, active listening going on. The advice he gave you just a moment ago, and I've tried to give you repeatedly through here, is it's never wrong to ask questions. Don't leap into the void based upon what somebody else has told you is right. If you've got any doubt about that at all, especially on ethical matters, call the Ethics Commission. Have the superintendent get advice. You've got multiple channels for advice that he knows of. And I'm really impressed, especially like Jim, I was unaware that you all have been serving a relatively short period. I'm sure it seems like a lot longer than it's been, but a relatively short time on the board. And that just paints pictures of all the great things you still have time to do. Thank you.
Thank you.
Thank you.
Thank you both.
Appreciate your time, guys.
Appreciate you.
Howard, Jim, I can't thank you enough. Every time I hear you all talk,
Thank you so
I
much.
think of this picture of somebody being up to their neck in alligators, and all you wanted to do was drain the swamp. Well, all any of us wanted to do was provide an educational